You've got Ted Corless with the Large Loss Podcast, brought to you by the Corless Law Group. Visit our website at www.corlesslawgroup.com or reach out at 813-258-4998. In just a few moments, we're going to turn you over to an interview that I did recently with Marcus Castillo. Marcus is a fabulous trial lawyer, absolutely fabulous trial lawyer with enormous perspective and experience in handling jury selection as well as participating in the prosecution and defense of lawsuits in a civil court. He also brings an enormous wealth of information associated with employment law. It's an area that I don't practice, and I'm certainly glad he's here to help. Here's Marcus. Marcus, let me begin with a simple question. How many years have you represented either companies or individuals in employment matters?
Sure. So I dove into the employment law area around 94. And the reason I did it was because in the early 90s, 1990 is when Congress passed the Americans with Disabilities Act, followed by the Family and Medical Leave Act the following year, and then the Florida Civil Rights Act, which is the analog, the state law analog to it, the year after that. So there was a real sort of evolution in the law. And I'm omitting the Civil Rights Act of 1991, which created jury trials in employment cases. So there was this harmonic convergence, if you will, of employment rights in the early 1990s. So my personal story was that I was coming off of working for a large firm in 93. And so after getting my feet on the ground, was deciding what I was going to do when I grew up. And I saw that, hey, this is an area for me to experiment in, and soon enough realized that it was for me. So that's how I started doing the work.
Got it.
Was because that was the direction the law was moving in. I had a base of experience doing trial work, doing injury law. I think not unlike what
everybody pretty much does it.
Yeah, to get your feet wet on the civil side.
Sure.
And had done it by that point both on the plaintiff and defense side. So I thought, hey, I've got a full rounded base, and here's a new area to dive into that really nobody has totally figured out. I'll just jump in with everybody else.
Right.
So that's how it started.
Now, when you were a younger lawyer at that point in time, were you working at your firm, the bigger firm, representing the defense side with the companies, or were you working with individuals who were making claims against employers? Okay,
so when I was working for the large firm, we weren't doing employment law at all. I had come from first working for a plaintiff's firm for 6 years doing personal injury and commercial work, to then working for a defense firm, working for State Farm and other carriers you're familiar with, doing both personal injury and property stuff, starting to get my feet wet with some employee benefits stuff on the plaintiff side because they let us do a little bit of plaintiff stuff. So it was like, I was whetting my appetite enough to know I was ready to go back to the, to the plaintiff side. So we weren't doing employment law stuff at all. In fact, back at that firm, some of these laws I described a moment ago, it still had not come into fruition.
Got it. I learned early that if a state passes a law that is described to the benefit of the individual, it's not. Okay, illustration, I was doing tobacco work in Louisiana.
Yes.
And Louisiana passed a Human Rights Act for the benefit of the people of Louisiana. And I assure you, the contents of that bill were not about preserving the rights and helping individuals who'd been injured or damaged as a result of others. It wasn't.
Right.
Most of the time, they're creating all of these lovely defenses for the parties who are ultimately going to be sued. So tell me, when Florida comes out of the box and says, and you said in 94, right around that time frame, they passed an analog to the federal law.
Right.
Was that, how would you describe that? Was it how fair was it?
Well, I'm not pushing back necessarily, but the Florida law, I'll say things this way. most practitioners in the employment world, plaintiffs' lawyers, I mean to say, if they had their druthers, they'd rather pursue a case, at least now, in state court rather than federal court, because you had so much more of an opportunity to get a trial. Because, as you know, federal judges can be very summary judgment happy.
Well, they can be very hostile to the use of their courtrooms for, say, jury trials.
Right.
Yeah, exactly. They don't like that.
That's right. That's right.
Yeah.
So I hear what you're saying in terms of, how things can become almost Orwellian,
So it is this idea that when you go into employment law, if I were a young lawyer and I'm thinking about doing employment law, I probably need to understand that I'm looking at spending a lot of time in federal court. And that's a very different practice if you are a young lawyer coming in doing mostly personal injury or other commercial issues as a guy here in the state of Florida. I mean,
that's absolutely true. Most of the laws that we say are the body of employment laws are federal. And even if you sue under the Florida statute, if you're suing a larger employer, typically they're going to be based outside of Florida.
So you get diversity jurisdiction.
You're going to be in because of diversity. So you're going to end up there. Okay. Now, one of the things I observed a minute ago was that, hey, at least historically, a lot of practitioners were filing in state court because of the summary judgment threshold on the federal side. But what's happened on the state court side?
Right.
We just adopted recently the federal summary judgment standard. So it's all in transition.
And, I know I'm not trying to go down a rabbit hole on that, but I've spent some time with that new rule. And it's this idea, for those of you who are not as familiar with the procedures of the law, summary judgment is where a judge makes a determination that everyone agrees on the law, and we even may agree on the facts. And if I take those facts with that law, you lose. No jury trial.
Right.
And recently, there's always been a difference between how easy it is to get summary judgment in state court, whatever the case may be about, versus getting summary judgment in federal court, where I recently tried a case where the judge indicated they hadn't had a civil jury trial in 3 years. And that's because this judge was handing out summary judgment orders like Easter eggs. And that's just because they didn't want to go through the cost and expense and inconvenience of a civil trial. But now there's been this adoption by the state of Florida with the idea that our summary judgment standard is going to be the same as the federal court. What I do like about that new change is that under the rule, you have to respond to the summary judgment motion in writing, and your response has to be filed within 20 days, prior to 20 days of the hearing. I can just tell you, and this seems like a subtle difference, but as someone who's argued summary judgment motions on both sides of the ball, routinely in Florida, you would get ambushed at the hearing because now out of the blue, somebody stands up and says, oh, well, we've actually found the missing link that puts all this together for us. And either now you lose or now I win. And what is your reaction in the state of Florida? You've been to many other states. How is it if I'm a litigant and I'm in employment? I've got an employment case where I think somebody has done something wrong to me and they violated some rule, or maybe it's my mother or it's a other family member. Is Florida a hostile place to these kinds of employment cases?
Again, keeping in mind that the majority of the cases are litigated in federal court. All right, so when we talk about Florida, we're talking about, in large part, the Florida federal courts. But yes, of course, some cases are litigated in state court. Florida can be a hostile place. I mean, let's talk a little bit. Let's unpack that a little bit because, in the first instance, we have all of these laws I've described. Well, I haven't described them. I've mentioned a few of them, but we have Title VII, we have the Americans with Disabilities Act, we have Family and Medical Leave Act, we have other, Age Discrimination and Employment Act. We have all these laws that prohibit discrimination, retaliation, harassment, all those sorts of things. So in the abstract, it seems like, gosh, the law, the quote unquote law is friendly to plaintiffs. But it really gets down to the process and the judicial process and how these cases are decided. And, you talk about summary judgment. Summary judgment is a huge gauntlet in these cases.
Right.
Because in these cases, the plaintiff can establish what's called a prima facie case, but then you have to then overcome the defendant's argument that whatever happened, we're talking typically about termination cases here, they'll come up with some reason, and the case law says that their burden is light on summary judgment to rebut the prima facie case. And if it turns out that they come up with something that's halfway plausible, although wrong, although a lie, then the plaintiff has to prove that was a complete pretext to survive summary judgment. So it's not easy. I tell folks, that come to me that I'm willing to take on any fight that's worth fighting, but we need to know, and we need to be, understanding how hard the fight can be up front.
All right. So you said that you mentioned the issue of termination. Right. So before we go into a few of these, because I'm very curious about issues associated with each one of them, the categories of cases that you would have plaintiffs come to your office to sit down and talk to you about, improper, illegal termination, is that?
Sure.
Okay.
Sure.
But my understanding, let's start with termination before we talk about age or ADA, things like that. And there's been some expansion of the ADA, I understand. Yes. It applies now to certain websites, which is fascinating.
It does. That's under another title of the ADA, but you're absolutely right.
Yeah, that's really interesting. We'll get to that in a minute. But this issue of termination, I guess I've only been fired from one job in my entire life, and that was when I was working at a movie theater in St. Joseph, Missouri, and I made the terrible mistake of leaving the keys to the supply room where all the napkins and uncooked popcorn was being held, and I left the keys there, and I got fired. So I was making $2.85 an hour,
right.
16, 17 years old when I'm working at this movie theater. But that's the only time I've been fired. But explain to me how it is that if we are, I believe, an at-will state, which means you work at the will of your employer until they decide otherwise, how does a wrongful termination case come out of any kind of facts like that?
Sure. So you're absolutely correct in telling the audience that Florida is an at-will state, which means you can be fired for any reason, no reason at all, even a wrong reason. Okay? That's the default you always start with. But that default general rule falls in the face of a statute passed by Congress, the legislature, or a local government that prohibits any form of discrimination, harassment, or retaliation on the basis of, various classes, like being disabled, by being over 40, by being black, by being a woman, by being pregnant, et cetera.
Okay.
So statutes overcome that.
Okay.
Right.
Meaning that I can fire you for any reason except these.
Except for these prohibited reasons that Congress or the legislature has said you can't do it for that reason. Now,
I'll invoke a kind of a personal experience that I had.
Yeah.
We had, this was back in about 2015, I think, and I had half a dozen lawyers working with me, half a dozen staff members. So we had 12 people. We had a particular employee that just could figure out how to screw up just about anything that they did. I won't even give you I have to give you the gender when you understand why I'm asking you this. And so I went to some of the lawyers, and maybe I was a little bit harsher on her. That's what always happened. If you have a bad employee, half the lawyers in the office are, that person just, they blow deadlines. They don't follow directions. They're late in the morning. They leave early. They took 2 hours for lunch, that kind of stuff. But then the other half of the room is like, oh, man, they're so great. I'd love to work with them and everything. So I didn't make a big deal out of it because I came forward and said, I think we need to replace this individual before she hurts somebody. Well, she comes to us maybe 2 months later and shares with us that she's pregnant. Mm. And, well, congratulations. That's terrific. Well, so a couple of days later, she really royally screws something up that two of the other lawyers in the office were working on. And they came in my office. They're like, all right, you're right. We got to let her go. And I said, I can't fire her now. She's pregnant. And I'm not going to do that. And so a couple days later, one of the lawyers comes to me and says, listen, I've got through our payroll company, they had you have questions about an employment issue, you can call this person. So we set up a phone call. And what the lawyer said was, well, here's the thing. You're right. You can't fire someone because they're pregnant if Title VII applies to you. And it doesn't. And I said, it doesn't? They said, no, because it only applies if your company has a minimum number of employees.
Right. So
is it 15?
Yeah.
Okay.
So the answer to that, where you're going with that, is that under both the federal law, Title VII in this instance, and the Florida Civil Rights Act, they both require 15 or more employees for coverage to exist. So the law, as you correctly state, doesn't apply to smaller employers. Now, before we just, I'm
going to tell you after you answer this, I'm going to tell you what we did.
Okay.
See what we did.
But before you just close the book on the analysis, you have to also consider whether there is a local agency. So, for instance, in Pinellas County, and I believe in Hillsborough, but I know in Pinellas County there is an Office of Human Rights, which enforces an ordinance that applies to employers that employ 5 or more employees. So, I don't know, in this situation, but, that's always the fallback you have to look at. But you're right.
Sure.
At the federal and state level, 15 or more to trigger it.
Got it.
For that law. Now, I won't get too
There's others. Okay.
There are other laws
there.
with other
Sure.
thresholds, but yeah.
Sure.
Yeah.
Well, because this could be somebody who is pregnant or has a pregnant family member, or it could be someone who employs someone who's in that situation. Right. My decision, because it was ultimately mine, was not to fire her because, first of all, I just karmically didn't think it was a good idea to fire a pregnant female. I just didn't think that was the right thing to do. And we were just going to have to watch her for a while. Second, the problem I had with it is, well, wait a minute. And let's jump forward 10 years from then. And maybe in 10 years, I have 18 employees and a woman who is pregnant gets fired and for cause, really good cause. I'm sitting in a deposition and someone says to me, have you ever fired someone because they're pregnant? Well, I have to answer truthfully. And it would have been, if we had fired her, my answer would be yes, which to me would be potentially probative evidence that I discriminate against or use women's particular situations against them. And I'm like, I'm not going to play this game of that wasn't an answer that I would have been satisfied with. And so we kept her and then we gave her a whole bunch of extra, and because here's how I got out of it. We gave her a whole bunch of extra time off, paid her for all of it, but told her, I have to replace you when you're gone and your job's not going to be here when you come off leave. That was a solution that I think got everybody where they needed to be.
Right.
But it was within the context of an appropriate decision made within the standard, within the law.
Yeah. I mean, let's just talk for a minute more about the employer side of things, because you may well have folks employing people that need to hear that side of things rather than plaintiff only here. And that is this notion that you need to keep track of your employees and you need to document your personnel file. If people are screwing up, you need to put it in the file.
Right.
Because if you don't and you get sued ultimately for the termination, they're going to be asking you in a deposition at some point, what's your backup for your reason? If you don't have it documented, you're going to have problems.
Oh, listen. Then there was the case, the claim where we had an employee that I really, really, really liked. Really, really liked. And again, I think it was one of those situations where I don't know that the other lawyers in the firm liked her as much as I did. Yeah. She was African American, and just again, I really liked her when she was on, but she did without the details aren't relevant. She screwed something up, and this is usually in my experience in working in law firms. You don't get fired for the screw up; you get fired for the cover up, because the cover up made it worse. And then when the lawyer who was in charge of the case found out, she was so livid that she was like, okay, I'm not going to work with her anymore. And so we had a file on this woman that was, I remember we fired her on Halloween, which that was more of an issue for her than, so we sat down with her and we had these notebooks. We had one of the business managers present and we had these 3 notebooks, one for her, and it had 17 tabs in it. And we were like, all right, here's the situation. Let's go to tab 1. You did this, 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 and this. Then you were asked about it. You lied about it. Then you tried to file this document in court after it was no longer permitted, and we got sanctioned by the court. And the problem was you were trying to cover it up. And I've always told you guys, mistakes happen. There's so much paper floating around this place. Stuff is going to happen, but you can't try and cover it up. And so then she's like, no, I understand. So then we went to tab 2. And then she just kind of put her hand out on the table. She goes, listen, it's cool. You got me. Okay, yeah. I'm out. Right. Like, oh, you got me.
Right.
So now fast forward 2 years. She reached out to me. She moved to Atlanta. And she reached to me and said, hey, I'm applying for this job. Will you give me a referral? And I said, well, I don't want to hurt anybody. I'm a fan. She knew that. So she sends me this thing to fill out. And the last question was the killer. It said, would you rehire her? And I'm going, well, hell no, I wouldn't rehire her. You know what I did? Oh, yeah, I'd hire her right now. No way. I don't need somebody going the rest of their life, didn't get a job because I was dissatisfied. I said, absolutely. I'll write a letter of recommendation if you want. I don't owe any of these future employers more information than this. So
I don't blame you.
I just leave it alone, help her out. She got the job. So
I don't blame you at all for doing that.
So
yeah.
Okay. So that's wrongful termination.
Right.
The one that I think is, and you and I have had a couple of situations where I've referred people over to you, is this question of age discrimination. That seems like if you've got something on an employee or nothing on an older employee, that seems like the one where it's going to be kind of a he said, she said as to why they got fired.
It's interesting. I had a case not too long ago, and it was in front of one of the local judges and federal judges, and she made some comments at this hearing about, what she thought were, in her mind, meritorious cases versus maybe not so much. And she just, out of the blue, made this comment about folks that have been there for a long time. He says, I just look at those cases, which would, of course, be the age case. I just look at those cases differently. You're going to have a harder time to convincing me, Mr. Employer, that there was something that bad about this person.
Well, if they worked for you for 25 years, they're kind of the devil you know. And right. If they lasted that long, unless it's some kind of new issue, they've suddenly started drinking on the job. I had that one. I had a 7-year employee start drinking.
Yeah.
That was interesting. Yeah.
Yeah. But, we're kind of in the camel's hump of the baby boomers being on juries, right? And so there may well be that sympathy for age cases.
That empathy,
right now.
yeah,
empathy,
right. Yeah, right. Yeah, right.
Yeah.
What about me? Right.
I would agree that age cases can have a special allure. Now, you always have to deal with the reasons they're going to come up with. You better deal with those up front,
I mean, is it smarter for an employer to just keep it thin, keep their file thin, and just say, we fired him because we're done? I don't know.
I'm in favor of documenting the file.
Heavily, okay.
Yeah, because otherwise the lack of documentation is going to come back in discovery.
Great cross-examination questions.
Exactly.
Show me the write-ups that you had none.
Right.
What are you going to say? They were so bad that they weren't even worthy of a,
right.
I know small business people, we get busy. I mean, we've got a lot of people pulling at us, both at the office and at home, and it's easy to not take the time to sit down and write a note to the file explaining the conversation about the problem and what you told them they need to do and following up in 90 days to how
Right.
has that conduct been corrected. It's a lot of work.
It is. Now, there's one thing I want to mention. I don't know if this is in context or not, but I want to make sure if we're going to talk about wrongful termination, that I've at least mentioned this idea of retaliation, okay? Because any plaintiff's employment lawyer is going to want to put that in play if a potential client comes in and the potential client's on the verge of being terminated, or at least is on track to be terminated. One of the things that any plaintiff's lawyer would want to do is tell the prospective client, hey, look, have you complained about whatever it is that you're saying, like that you're being harassed because of, your pregnancy, or you're being sexually harassed, you're being grabbed, groped, et cetera. You've got to complain. You've got to use whatever the mechanism is that's being described in the handbook. You got to do it. And you have to oppose the harassment, the discrimination, the whatever. And if you're then terminated, within a short period of time after you oppose the discrimination or the whatever, you have a separate claim, a separate count in any lawsuit for retaliation.
Understand.
And you don't have to prove the underlying discrimination or harassment. You just have to show you had a good faith, reasonable person belief that it was occurring. So when we talk about termination, be it age or whatever, there is this separate notion in employment law of retaliation. So the underlying message there is to complain. Look at the handbook and complain about it. And on the employer side, you better have a responsive, actual complaint mechanism, not some just hokey pokey little thing in your book.
So here you keep triggering these stories from my practice when I was a young lawyer.
Yeah.
So this would have been in 1996. I was licensed in Missouri in 95. And in 96, my then father-in-law came to me. He was working at a funeral home, and he had discovered that the funeral home had made some financial arrangement with one of the local hospitals that when indigent people would come in to the hospital, if their children died very young, like right at birth or were stillborn or right maybe a few days after, that they were agreeing to cremate those children and then dispose of the ashes in some ethical way. He discovered that they were actually taking the babies, and these were babies. We know they were babies. We had because some of the children, he said, actually had bracelets on. So they don't put bracelets on dead children. He discovered that they were actually taking the children and putting them in the bio waste and just throwing them in the trash. So he came to me and he said, what am I supposed to do? And so we kind of went into a gathering of information phase, because he said that he knew that there were 20 babies and at least half of them had been put in the bin, and that they were going to put the rest of them in. So it was kind of dynamic when he brought this to me. But by the time he got to me and we kind of sat down and discussed it, the other 10 babies had been tossed in the trash, and that was the end of it. Well, fast forward about 90 days, another giant box of babies showed up.
God.
And what had happened was they sent the box of babies to the crematorium, but the crematorium wrote back and said, these are infants. We don't cremate en masse. We're going to charge you per baby. That was the play. The owner of this funeral home thought that they could charge one baby per, or like put all the babies in one box. That's $300. No. There's 20 babies. It's $300 a baby. Well, now all of a sudden they're upside down on the deal they had with the hospital. So while this was all going on, the second time we sent him down there to take photographs at like 3:00 in the morning. We had and
That's horrendous.
well, at that point, we didn't have digital photographs. So he goes down there, he shoots all this stuff, and he shows up at my house at like 4:00 in the morning with all of this it hadn't been processed yet.
It was in a canister,
It was just in those little black and gray canisters we used to get. I ended up setting up a meeting with the editor of the Kansas City Star. And we go in there with the photographs. We're like, you guys are going to have to develop these. We can't take these to the photo mat. And he never tells his employer any of this stuff is going on. So I remember I left town to go to Lake of the Ozarks for a long weekend. And Saturday morning, I get up and I walk into the 7-Eleven to get a coffee. And there on the front page of the Kansas City Star is this funeral home has been throwing children in the garbage. So the company, we're getting to the employment question for those of you out there who want to know where this comes in. So they have the next day, they had this big meeting at the funeral home, and they want to know who's the rat. And so everybody just freezes. And Bob was my father-in-law. What a great guy. Stands up and says, basically gives it up that it's him. And then he walks out the door and quits. So we spoke with an employment lawyer at that particular time as to whether or not he had some kind of cause of action for not termination, but constructive termination, meaning that he had been put in an impossible situation where he had to quit his job. We could not find an employment lawyer to take that case. And I was kind of pissed at him because I said to him, even if you wanted to stand up and give it up, you shouldn't have quit. You should have let them fire you. Because the minute they fired you, we were getting phone calls from CBS in New York. I was a one-year lawyer. I had, maybe 13 months out of law school. I have to tell you, the law part of it was pretty cool because I was in the middle of all this, But the employment issues were like popping up all over the place over this thing, and some other employees were arguing they couldn't work there any longer. And all right, I'm going to let you take that. What do you do with that?
That's great. Okay, so let's unpack this. So one of the concepts you put out there was this idea of, hey, he resigned. Shouldn't he have allowed himself to be fired? And I think that's a good piece of advice there. But let me put out there as well, there is this notion in employment law known as constructive discharge, which basically says there are some situations that are so egregious, like where you're under like relentless harassment, that sort of thing, where the law could say this is the equivalent of having been fired. Okay, so it's possible to construct a termination case out of a resignation, but it's hard. Okay, this goes back to where we're litigating these cases in Florida, where there's an entire body of law that talks about how freaking hard the threshold is to meet on constructive discharge. So you start with that. But the other piece too, just to at least be thinking about is, we've talked about Title VII and all these other anti-discrimination laws, but another employment law we should at least have on our radar is whistleblowing.
Got it. Right.
And I'm not talking necessarily, although there's a piece that's related to it, of key tam, which is basically blowing the whistle on government fraud.
Right.
But there's an entirely separate body of employment law that deals with, and this is both in the public and private sector, dealing with being retaliated against because you opposed something that was illegal. Now you have to, in Florida there's a disclosure requirement. There's some hoops to go through.
Right.
But if you oppose an illegal activity that your employer is engaging in, or threaten to disclose to a governmental body that that's happening, you have protections.
Understand. Yeah, I think the one that I heard about was a woman who blew the whistle on a drug company in Puerto Rico that was violating all of these quality control issues.
Right.
And she went to the government. She got fired for doing it, and she ended up hitting them for I think under a key tom, you get like 25% of the money that is associated with the loss. And this was like $1 billion. This woman now she got like $200 million going after her.
Enormous cases. It can be enormous. It has to deal with government fraud in some ways, and the usual nexus is Medicare. Medicare is being overbilled for something.
Got it.
Right.
You work at a hospital and you realize that they're billing for materials and for surgical procedures they're not even doing.
Right.
Yeah.
Exactly. Yeah.
Wow. Well, all right. So let's talk a little bit about the ADA, the Americans with Disabilities Act, passed 1996.
No, it was a little earlier than 1990.
Right? Okay. And it was Bob Dole, just recently died, senator from a Republican senator from Kansas. Now, he had I believe it was his right hand
I think so.
that
Yeah.
he was that was partially disabled, and was it polio, I believe? I don't remember what it was.
He had a wartime injury.
Okay.
That I think, yeah.
It's kind of in the same vein as like with John McCain.
Right.
And was it McCain who used to always walk around with a pen in his hand?
No, I think it was Dole.
Was it Dole that did that? Okay.
Yeah.
Yeah. Which Dan Aykroyd does the best Bob Dole impression, for those of you from Saturday Night Live back then. But
Right.
All right, so the reason I mention that is that it just doesn't seem to me like the Americans with Disabilities Act and the things that it did and created, that doesn't sound like a very Republican bill that he would have sponsored and passed. But it was an amazing piece of legislation.
It was.
It really was.
Indeed, and it was signed by the first Bush, right?
Yeah.
It had pretty sweeping, ideals and goals. Now, here's what happened. There's been a back and forth, sort of a tug, if you will.
Okay.
It was passed with good intentions. I believe that most lawyers would agree that in the first decade of the law, that there was major judicial pushback. It was construed in a way that was very narrow. For instance, the way disabilities were defined was in many instances in a way that favored defendants and led to summary judgments. Now, what happened is there was an amendment. There was an ADA Amendments Act passed about 10 years ago. I may be off by like a year or so, but Congress pushed back on that to, again, expand the definition of disabled persons and qualified individuals with disabilities. So there was that pushback there. It just depends on who's in power because, guys, whoever's in power, who's president, who's controlling Congress is going to decide who are the judges.
Right.
It does matter here. But at the top of the hour, you were mentioning things like websites, right?
Right.
Okay.
Right.
So there are 4 different chapters of the ADA. Title or Chapter 1 is the employment chapter, but Chapter 3, dealing with public accommodations, sweeps a lot of additional stuff. A lot of you probably heard about these, lawyers that will just basically descend on a business, with somebody that's a professional wheelchair, tester type person.
Oh, right.
And judges, the district courts aren't real crazy about those cases. They've been,
I understand.
But it has now entered into the, the arena of websites and whether they are sufficiently accessible to disabled persons.
Right.
Okay. And that's
I have a website. Does it have to be ADA compliant?
Well, there's a standard, and I haven't looked at that in the past couple months.
I sprung that one on you.
Yeah. But there actually are some standards that relate to readability, right?
Okay.
And that, in large part is what it's about. Yeah.
All right. Now, the last subject I want to talk to you about in employment is this issue of gender or sex discrimination. I have a daughter in middle school, and what you find if you have a child in middle school, high school, is the amount of energy that is spent by these kids addressing the issue of transsexual or this idea of they and them as opposed to he or she. And I guess what I want to understand is, how are the courts addressing this issue of individuals that are alleging that because they're either homosexual or transsexual or anything other than heterosexual, that they're being discriminated against? And are the courts honoring that within the scope? I mean, when they wrote, obviously, I don't think when they originally wrote Title VII, there would be any legislative history talking about what you would describe under the LGBTQ plus universe. But now that is very much an issue. And it is pretty amazing to me the number of people that I have met in my own galaxy that are not just homosexual, but are transsexual or potentially even transitioning. It's a very in-your-face place right now, and it seems to be evolving. How is employment law dealing with that?
So the answer to that is that there is a U.S. Supreme Court case that came down last year, and my mind gets a little discombobulated because of COVID, whether it was last year or 2020.
I lost 2 years. I have no idea what happened.
Sometime during COVID, right?
Yeah,
so I may be off by 1 year, but the U.S. Supreme Court recognized that homosexuals and transsexuals enjoy the same protections as heterosexuals under Title VII. So that is a clearly at the Supreme Court level protected right now. You cannot be discriminated against or harassed or retaliated against because of that status.
Understand.
Now, in terms of what the lower courts are doing, I think it's too soon to tell. I am not aware of a trial dealing with those issues in the Middle District of Florida in the past year. But again, as you and I know, they're really just now getting into stride with trying cases in person to begin with.
Right.
So I think it's too soon to tell what's happening with juries, but it's from a 30K level, it's a recognized right now.
Understand.
Yeah.
Okay.
Yeah.
Well, I wish those people the absolute best, and I don't see any. I hope that we can transition through that. I think that as we evolve, those issues are not going to be as prevalent. I know that it's not unusual for my daughter to meet couples that are married that are same gender, or that people seem, I don't know the vocabulary. I wouldn't jump in because I don't, but is this idea that as society becomes more accepting of those, then those issues are less. No one would even think about talking about gender discrimination without thinking about homosexuality. I think it's taken people a little bit longer to get to what they describe inaccurately as choices that are being made by these people, because I don't believe they're choices. I think they're discoveries is what they are. They discovered who they are, and they want to be who they are in the world where they work or where they live.
It's interesting, though. You may see who knows? I wonder, let me put it this way, I wonder if there will be a divergence in the law, because I think what we're talking about is going to be here to stay, at least for a while. But on the other hand, we have the Roe reversal, if you will.
It's a big deal.
And the logic, the underpinning of that is a right of privacy that underpins the same notion that homosexuals can marry.
Right.
And if that is
swept
away, then that could theoretically fall. But yet, I mean, it's a different logic. It's a statutory interpretation on the employment side.
Well, I know that I read the abortion opinion. Gunn, is that what it was? Is that the name of the case? I don't remember the name of the case, but I read it, and you even have an opinion, a concurring opinion that was written by Justice Thomas, where he raises all of those issues and says maybe it is okay under state law to discriminate as opposed to relying upon the 14th Amendment's rights of due process.
Right.
I certainly hope that we don't go that direction. This is a nice transition for us to slide into. One of the things, Marcus, that you and I talked about is I love bringing people in who can talk about their experience to things that are important to so many people in employment litigation. I don't know if there's anybody who would ever go in their professional life and not somehow be involved in an employment issue at work where you're on one side or the other of it, or a family member comes home and tells you they've been fired, or there's misconduct. So I think it's so great to have you here to share that experience. But I also want to ask you about something that's more in today's news. And so the topic that you and I started to kind of talk about before was you're talking about this kind of pullback by governments, that have been taking instructions from a lot of courtrooms for a while, and now they're starting to kind of flex their muscle. So you take a look at people who are governing us. So I want to ask you about Ron DeSantis. Now, a couple of observations you don't have to agree with, but just a couple of observations. DeSantis has redefined the role of the governor, and he is not defining it as a so-called conservative. I don't know what the hell conservative means. I know people call themselves conservatives, but then you have people like Ron DeSantis who's trying to reach out to this MAGA group, and he's doing things like picking a fight with Disney over whether or not Disney supported his opposition. That was really the issue. It wasn't that they have always been very pro-LGBTQ. And if you If you know anybody who works there, it's because if you ask them, they'll tell you that they have a large contingent of people who meet that classification. But then you see him picking fights with the Special Olympics, telling the Special Olympians that they would not allow them to have their event in Orlando. He says, because he knows better, that they had a rule that in order to be here, you had to be vaccinated. And he told them he would not allow them to have their event unless they removed the vaccine requirement. Then we saw him getting in a fight with the Tampa Bay Rays. Right. And that was over the fact that the Rays put out a positive, let's do something to solve this issue when it was talking about the Uvalde shooting. And so I just want to ask you, what is your impression of because what the hell is Florida?
Right. We were having this conversation, and it's multi-layered for me because I'm a Florida native. I have lived here almost my entire life. I now spend the majority of my time in Georgia, where one would think I would be in a much more conservative, let's call it a redneck environment.
Right. But that whole Civil War thing, kind of gets in there. Yeah.
I live when I'm up there, near a road called Terra Road, right?
Oh, really?
Wind, right?
Wow.
But the truth of it is,
if those of you who've not seen Gone with the Wind, you need to just hang up on this podcast. But Gone with the Wind, yeah. But go ahead, yeah.
But, so I have this perspective of going really pretty far back in time here, right? And I was having a conversation with my late first wife about Florida years and years ago, like over 10 years ago, and we were like, do we still want to live here? We're seeing things change, and this is before DeSantis came on the scene. Mm-hmm. But to me, this whole trajectory, he's accelerated some things I've seen going on that really bothered me for a long time, know. But just staying on DeSantis, when he first was elected and it was inaugurated, got into office, he did a thing or two right in the beginning. I remember him doing some things related to the environment, something to do with the Everglades. I thought
talking about something to do with Big Sugar.
Yeah, I thought maybe this guy isn't so bad after all.
Yeah, because Rick Scott was huge in bed with a lot of the individuals that were just destroying the water sources.
And he was supportive of medical marijuana and that sort of thing. So my first impression was this guy's maybe a moderate or something like that, and that maybe this guy won't be quite as bad as I feared. But then we get into COVID.
Oh gosh,
we get into COVID, and his approach is very. But I found appalling that whole scene with those kids. They were pull-out kids on a stage, shaming them with the mask. I mean, regardless.
He yelled at them and corrected them for masking up in a public place.
Right. So whatever your thoughts are about masks, shaming some well-intentioned kids was just, it sold, I'm sure, but I found it just very disgusting. I was going to say off-putting, but I felt stronger than that.
Well, right, because it's like red meat to his base, and I don't know, and because are these people conservative? Is that because I've always described myself as fiscally conservative, but socially moderate.
Right. In fact, I'm going to say this live on the air, but aren't you? I'm a Republican, and I think the last time I checked, you were as well. Maybe you've changed, but
well, here's the thing: I had to become a Republican because we were fighting the state of Florida to pay a very large insurance claim. And I had to go to all these Republican events to give them money to get them focused on this. And I was told they had looked, and I was not invited if I was not a registered Republican.
Look, the Republican Party, we talked about George Bush a little while ago, passing the ADA.
Right.
I was that kind of Republican.
Right.
The same Republican. Right. I mean, we could say, look, I know you've got a poster of Nixon's
right.
on your, but Nixon actually passed the legislation to stop the barge canal and a lot of other things that were really terrible for the state of Florida. But the point here is, where has the party gone and where's our state gone? Because like I said a few minutes ago, I've been here over 50 years.
Right. The
place is unrecognizable in a lot of ways.
Oh, I agree. And I'll probably push back a little bit that Ron DeSantis claims to be pro-marijuana legalization. He's against recreational in all forms. My problem with him is what I think the real problem is that Ron DeSantis believes he knows better than everybody else. And he thinks government is the solution.
Which is completely antithetical to millennium conservatism.
Right.
At least Reagan Republicans.
What is the famous Reagan quote? The scariest thing you'll ever hear is someone who says, hello, I'm from the government and I'm here to help. And you got DeSantis, who is everything but conservative. And all these people are so driven by the result. The process doesn't matter to them. They just, oh, well, here's what we want. We don't want you talking. We don't say gay in school. And now we're seeing the ridiculous results. There was a story that came out yesterday about how school had to return dictionaries because there was a concern that it might have violated the law that he just passed. I mean, what? And these people are standing up. I see the signs, conservative fighter. And you're fighting against the people, and you're using government to do it.
And a discussion we were having before we got on the air with this thing is, what exactly does woke even mean? Because we know that there's a war in Florida against woke.
Right.
But
I can't find any of them.
If woke means, that you are pushing back against full-out blatant racism, then I guess I'm woke.
Right. Or, remember the whole thing about Black Lives Matter, which he was very much antithetical to that.
Right.
The point is that they aren't pulling over 50-something white guys driving Teslas and shooting them.
Right.
They're not. They're pulling over African Americans at an alarming rate, and they're presuming violence, and it's unacceptable. And every time you try and talk to people about that issue of, I don't have to talk to my teenage daughter about how to talk to police. I don't have to concern myself with that. But I remember when Obama said, if he had his two daughters, if he had two sons, he would have to sit down with them and say, you are not like everyone else. If you get pulled over or you interface with law enforcement, you are going to get a completely different appearance than everybody else. And it can be so bad that it may very well risk your life or the other people that are with you. But this whole white people being offended, I thought all that offended part was for people who wanted government to come in and save you from someone else. And that's what Ron DeSantis does. So he's going to run against, I guess, either Charlie Crist, who's a former Republican, or Nikki Fried, who's the Commissioner of Agriculture, who's been very supportive of cannabis legalization. So she's heavy on my board.
But the reality of this is that DeSantis is probably going to win.
He is, and you even saw him on Fox News in the studio. That's a pretty big deal, because when I used to do a lot of studio work, it was a totally different thing for you to reach out to somebody with the face on the screen versus bringing them in the studio. On the day that Rupert Murdoch, owner of Fox News and the Wall Street Journal, published in the Wall Street Journal and had a whole bunch of showtime talking about that Trump was no longer their guy, and that now here's Ron DeSantis,
mega state governor of a purple state.
Well,
increasingly reddish.
Yeah, it
purple.
is. The purple is starting to
and it's like I was saying.
Yeah.
I think the hue of the state is darker red than Georgia is. I believe that.
Oh, I agree with that.
Yeah,
I absolutely agree with that. And so, last comment I'll make about the what is Florida? Mickey's a mouse, Donald's a duck. What the hell is Florida? Is just this idea that there are people who couldn't vote for someone other than a Republican. It wouldn't matter who it was. It wouldn't matter on what side. It wouldn't matter. They just could never do it. And I don't know if maybe we learned our lesson with 4 years of Trump, that when DeSantis stands up and starts pitching to those people, he's a hell of a lot smarter than Trump, but he's more transparent too, because it's obvious what he's doing. So I don't know. I think you're absolutely right. I mean, maybe the best thing that could happen for Florida is he become president of the United States. I don't know. Get him out of here. But it is this idea that I'm uncomfortable that the Republicans control every component, every brick of Florida's government. And what it means is they pass laws with no committee hearings. They introduce a bill on Monday, it gets passed on Thursday. It's not vetted. There's no pushback. This is the bill we're passing. We're going to sign it, and off it goes. As opposed to a community where two different sides of the issue will present information and two different perspectives or more, and then the legislators will vote their conscience. That is not what happens in Tallahassee.
Not anymore.
No.
If it ever did.
The last time I went to a hearing, it was the Banking and Insurance Committee up in Tallahassee, and they voted once. There were 17 amendments to this bill that were being proposed by the opponents. They just stacked them all up and said, anybody want to vote for any of these? Nope. Denied. And then they allowed the opposing party to call one witness, and it was an insurance matter. They called it was a Marine in full uniform who had just come back from battle, and he was dealing with an insurance company who had completely screwed his family when he was gone. And they allowed him to speak for 4 minutes, juxtaposed to the 4 hours of time that they had allotted to the other side. So I'm a big fairness guy. I'm also disgusted by hypocrisy, and that's what I see with the Republicans that are running this state, and I think they're going to continue to do it.
Well, as long as the structure, the gerrymandering and all those structural level things and campaign finance, all that, it's going to be this way maybe for a while.
Yeah, I think it is. It is.
Yeah.
Well, Marcus, do me a favor. I'd like you to identify your firm website, so folks who have questions about employment or anything that Marcus would be appropriate for, I'd love for them to be able to find you.
So on the law practice side of things, you can find me at www.haas, H-A-A-S, hyphen my last name, CASTILLO.com. And I also do some trial consulting, as Ted knows, and you can find me on that side of things at www.trialfocus.com.